Clients come to us with a submission release without even looking at it. There's a 90% chance that it's going to do three things. One is it's going to expressly waive the client's right to any form of injunctive relief whatsoever. Two, they usually expect the client to acknowledge that this production company already has, without even reading the screenplay, substantially similar ideas and materials to what their script is. And thirdly, it governs how you would enforce those rights if there was a blatant infringement. Usually it limits your damages. So I've read submission releases, for example, that will say, no matter what, even if we blatantly, willfully infringe from you, the most money you can get is $200,000. And in a way, you say to the client, listen, if they actually do steal it from you, at least you'll get $200,000. Clients will say, is this negotiable? And quite frankly, it's not. Submission releases are a way for production companies and studios to have a formal filter of, if you want us to review it and we don't know you, you have to limit your rights, because there's so much litigation involved with, clients or individuals who submitted an idea over the phone and sent the script to an assistant and then files a lawsuit 5 or 10 years later. So these production companies, studios, distributors are very scrupulous about what they take on. And to the extent it's from somebody they don't know, they do want you to limit your rights. It's really important with all of these attachment letters that generally, you as the rights holder do three things. One is you expressly specify that you are the underlying rights holder of the option or the screenplay. Two, you have a very clear, you very clearly state sort of what the consideration is and what it's tied to. So the scope is very clearly defined. So if there's a term, it's very clear when it expires, and that way, if somebody looks at it down the road, there's no ambiguity that can come back to haunt you. The biggest issue is if there's ambiguity and you make the movie, you will get a cease and desist letter, period, end of conversation. If there is specificity and you do what you're supposed to do under the agreement and you make the movie, then you have no problems. And if you don't make the movie, nobody cares because there's no money to get. Although there are frivolous lawsuits that we've seen come across our table where people will file a lawsuit because monies were about to be raised and hit escrow and never funded. So you do have to really be careful about the nuances of what you're obligating yourself to in those agreements. And then the third thing is you really want to make sure it always specifies that it's a work for hire. In other words, if the producers only attach, if they attach Julia Roberts, you want to be clear that any contributions that they make are work for hire, because if, for example, they met with you at Coffee Bean and they told you that in Act 3 you really should have a Ferrari throughout the movie, that doesn't somehow then entitle them to a joint authorship or ownership in the results and proceeds of the screenplay. So it's very important to specify whatever they may contribute is simply a work for hire so that you have no issues in your chain of title. Distribution agreements are extremely complicated, and in order to have a very intelligent analysis of it, a lawyer needs to first understand what a statement looks like down the road once the film's exploited, and you get the statement from the studio. How are you, for lack of a word, being screwed? And then kind of work your way back from there. So for me to give you all the tips and trades that I've learned in 8 years would be impossible. I will say that the distribution agreements are intended to be pro-distributor, so it's very important to understand the economics of the deal so that when you review the transactional language, you know how to customize and adapt and where you can modify the language to your client's benefit.